Good morning, everyone. It's Joe Adams here. Happy New Year. Happy 2024. We're just getting started. I'm still a little rusty from the end of the year and the end of the year celebrations. So I appreciate you joining me on today, the 4th of January, 2024. I've been an immigration lawyer for 13 years. I focus a lot on artists, entertainers, people in film and television, and the arts and their families. It's sort of a niche practice here in Southern California, New York, London, the major entertainment capitals around the world. Every once in a while, I like to get people together to share information, to answer questions. I've conducted dozens of these Zoom webinars and dozens of in-person seminars. And what I find is that the questions from the audience are always much more interesting than anything I have prepared. So if you have any questions, just type it in the chat. I know that there are people on the Zoom from all over the world, from Poland, I saw, from the UK, from Canada, several people from Mexico, someone from South Korea. So we've got people from all over. Raise your hand, type your question into the chat, and I'll do my best to answer everyone's questions. Okay, so what are we in store for in 2024 from the perspective of immigration? Well, we already have a sense of that because on December 27th, so 2 days after Christmas, while everyone was on holiday, the USCIS, the United States Immigration Service, came out with a new rule that said that the already very high fee for certain kinds of cases was going to increase even higher. If you saw my email blast or some of my social media postings recently, you see my outrage in this because an already outrageously high fee is going to be even higher come the end of February. And the reason I think that this might be a sign of things to come is USCIS, they will say, hasn't raised their fees since 2016 for the most part. They will say that due to inflation and hiring and just sort of the nature of the economy, that fee increases are justified. Obviously, we have no control over the fees. There's a whole group of lawyers who focus their practice on fighting fee increases at USCIS, the State Department, and at Homeland Security. And God love them. It's an uphill battle for sure. But my sense of where we're headed in 24 is fee increases. Now, like I said, if you saw my email blast or you saw some of my recent social media posting, the particular fee increase doesn't touch every sort of case within immigration. It only affects a certain kind of case. And let me just explain what that is. So there are certain kinds of cases where you can pay an extra fee, and we call that premium processing. You can pay an extra fee on top of the basic fee. So you have to pay the basic fee or the standard filing fee, but if you pay an extra fee, the government will review your case within an expedited time frame. That's only available for certain case types. So for instance, if you are pursuing, say, a marriage-based green card case, premium processing is not an option for you. But for a lot of my O1 visa clients, my high achievers in film, television, the arts, when we file their cases, the I-129 cases, those have the option of using premium processing, and also in our employment-based cases. So remember, there are many different ways that people can become green card holders and become permanent residents. One is through the employment-based process, or EB process, and I file a lot of EB1 cases and EB2 NIW cases every year. EB1 cases and EB2 cases have the option of paying the extra fee to get a quicker decision. And by the way, the last time I checked, an EB1 I-140, the last time I checked, the processing time was like 12 to 15 months. So however long it takes us to prepare the case, 2-3 months, sometimes a little longer, depending on how quickly we get the information. And then we file the case. If we're using standard processing, we wait a year, we wait a year and a half, only to hear back, we want something else. We don't see how this, we don't see how this criteria matches what you're saying, and we get an RFE. So I always encourage, especially my EB1 clients, to use premium processing, because that shortens the time frame down from a year and a half, where they're not really limited to how long they can process the case. It cuts that down to 15 days. But the trade-off is this exorbitant fee. When I started this practice 13 years ago, the premium processing fee was $1,000 even. Okay, so you had to pay the standard filing fee, which back in those days was like $300, $400, plus the extra premium processing fee if you wanted premium processing. Okay, $1,500, $1,600. Now, for the last 4 years or so, the premium processing fee was at $2,500. So in addition to, say, the $460 you pay for an O1 for standard processing, plus $2,500 for premium, nearly $3,000 just in filing fees. Now, as of February 26th, the premium processing fee will go up to $2,805. I don't know how they picked that number. It seems kind of like a random number to me, but that's what they did. And the justification is, of course, inflation. Everything's more expensive nowadays, cost of labor, cost of recruiting immigration officers, et cetera. So that's I think a sign of things to come this year. Also, it's impossible not to know, we are entering, well, we have been in what people call silly season. So, in normal times, every 3 years, things kind of go on like normal. And then when there's a presidential race, things get silly. Directives will come down from the administration. Changes will be made rather suddenly for political gain, for political purposes. People call that silly season, but for the last 4 or 5 years, it seems like every season is silly season. Regardless of that, immigration is always a hot topic in any election. It's an issue that a lot of politicians take on as one of their main issues. Even though we haven't had what I would call comprehensive immigration reform since the early 1990s, when I was a junior high student, barely an elementary school student, there is always a political football element of U.S. immigration. So I think what we're looking at moving ahead into 24 is the potential of fee increases and the various issues that will come up as a result of the political climate and the election, the presidential election that will take place in November of this year. So with that in mind, I also want to address the fact that that there's been no change, no substantive change to the rules that affect the vast majority of my clients. So sometimes people will reach out to me. They'll get information about how a particular immigration process works, and sometimes they just kind of disappear. They go away for a few years, and then they come back and they say, okay, I'm ready to go ahead now. Tell me about what has changed. And the reality is, throughout the Obama, Trump, and now Biden administrations, The substance of immigration law hasn't fundamentally changed. What has changed is the who decides element. So, and you may have heard me talk about this before, but basically during the Trump administration, there were high-level directives coming from Stephen Miller, from Donald Trump, in the West Wing of the White House, filtering its way through the civil service, through the bureaucracy, and then people were being instructed to, to do things, to enact policies that were, in my view, not very humanitarian oriented, and were and in some cases were just at opposites to immigration law. Then during the pandemic, there was a record dip in the number of cases filed. Usually every year the Immigration Service sees about 1 million cases come through its system. Well, during the pandemic, there was a record dip in the number of cases filed. USCIS, the Immigration Service, operates 99.5% of its budget from the filing fees that we pay. So the premium processing fee, the I-129 fee, et cetera, et cetera. So they're not taking money from Congress. They're taking money from the users, the customers in their parlance, who pay the filing fees. Well, with that low number of cases being filed, there was a dip. And so what happened is there was a threat, a very serious threat, that USCIS workers were to be furloughed. A furlough is where you're required to work, but without pay or for deferred pay. It didn't happen. There was no furlough. The Congress intervened and bailed out the Immigration Service. But the threat of the furlough, I think, was enough to say, if you're a mid-career civil servant, if you're, you've got mouths to feed and mortgages to pay and kids to send to college, you're looking to the door, and you're looking to maybe go into the private sector. You're maybe taking an early retirement. So there was a brain drain that happened at USCIS during that late Trump era during the pandemic. And now that the pandemic's over, now that Trump's gone out of office, it's been the job of the Biden administration to rebuild. But who are they pulling from? These are not glamorous jobs. These are not very well-paid jobs. So the immigration officers that we've been getting, in my mind, don't seem to have the experience or supervision or training that I would like to see. And the way that that manifests itself is we file a case, we get a request for evidence where the response to the request for evidence is, you already have that, you've mischaracterized something, you've applied the wrong standard. Just this week, I was working with 2 separate clients on requests for evidence responses where the government didn't even quote its own regulations accurately. They misquoted definitions that have been the same definitions since the early 1990s. So we're in a challenging period of time. We're in a period of time that will be a little uncertain given the politics of the moment. But if you've ever heard me on any of my webinars or in person or on social, the key to this whole game is persistence. Planning and persistence is the way to make your U.S. immigration goal happen. I'm reminded of this just right before the holiday break. I was able to hand someone a green card. She had been in the U.S. for many years on various visas. She had tried before with a prior lawyer. We were able to sharpen the arguments. We were able to, I think, improve the case, and we turned the denial into an approval in early 2023, and then the green card, the second step of the process was processed, and the card itself was produced right before the Christmas holiday. And that was such a relief, because this particular client had just really been through a lot of ups and downs throughout the years. I'm just going to pause for a second. If anyone has any questions, some new people have joined since we started. Again, my name is Joe Adams. I'm an immigration lawyer based here in Los Angeles, and I conduct these Q&As for free about once a month. If you signed up, I'll send you a recording of this conversation. And if you have any questions for me, please either raise your hand or type your question into the chat box, and I'll do my best to answer them. Okay, so if someone is interested in applying for an O1 category visa, that's sort of my bread and butter, the O1 category visa. Who wants one? Why do they want one? And how do we get them? So first of all, the O1 category visa is a special visa. In the big picture of immigration, it's a very narrow, small slice of the big picture. Like I said, there's about 1 million immigration applications that are filed with the Immigration Service every year. But amongst that million, maybe 10,000 to 12,000 are O1 category visas. But they're really helpful for artists, entertainers, people in film and television, and the arts. The reason for that, number one, there's no limit to the number of O1 visas that can be granted per year. So unlike other categories where there's a strict numerical cap, as long as someone's able to show that they're qualified for an O1 visa, there is a visa available. There's no cap. Number two, there's no limit to the number of O1 visas that can be granted per year. So unlike other visas that cap out at, say, 5 years or 7 years, as long as a person remains qualified and as long as they're filing new cases, there's no limit to the number of years the person can be on an O1 visa. In fact, the client I referenced a moment ago, who had just obtained her green card, had been in the US, I think, on 4 separate O1 visas over a 10-year period, 4 or 5 that prior counsel had prepared. So no limit to the number of O1 visas that could be granted. But in my mind, the most important and helpful provision in the regulations is a regulation that says for an artist or entertainer, the petitioner of the visa may add additional performances or engagements during the validity period of the visa without filing an amended petition. And I know that that's a mouthful, and I try to quote the regulation as accurately as I can, but let's break it down. So for an artist or entertainer, an artist is someone who uses creativity in her job. So not just a fine artist, not just a sculptor, not just a musician, but also someone who works in TV and film, someone who works in the popular arts, someone who works creatively. So perhaps they produce television commercials or instruct the career of other artists like an agent or a manager would. So for an artist or entertainer, the petitioner or sponsor of the visa may add additional performances or engagements, in other words, contracts, during the life of the visa without filing an amended petition. And this makes a lot of sense. When the O1 category was created a long time ago in the early 1990s, the government, to its credit, took a lot of testimony from various figures in TV, film, the arts. They talked to unions, they talked to regular workers, they talked to management, they talked to studio bosses, and what they realized was artists and entertainers, especially people at the top of their game, work in a multitude of ways that the regulations simply couldn't contemplate. You know, prior to that, people were trying to shoehorn their careers into office worker or factory worker kinds of scenarios. But most artists and entertainers don't work like that. But then again, there are immigration officers who don't quite get it. I recently, right before the holiday, had a request for evidence. A very high profile film editor who had 3 separate upcoming unrelated projects from 3 separate employers. We filed the case. The Immigration Service didn't question his relative level of ability. They were satisfied that he was a high achiever, but they said, how could this person have 3 separate jobs as a film editor at the same time? And the client and I just sort of shrugged our shoulders and said, I mean, how do they not know that? How do they not know that a film editor will have a multitude of projects going on at any particular time? So we had to do we did some research. We found some news articles talking about achieving work-life balance as an editor while you're working on several different projects. Found an article about how working in different genres can be informative from one to another as you go about your day, working on different unrelated projects. And then finally, I decided to ask ChatGPT and said, ChatGPT, is it common for a film editor to work on multiple unrelated projects at the same time? Yes, of course. And ChatGPT provided its answer, which I snipped into the response. That case was approved. But what it shows is that we always have the burden of proof, and it's up to us to educate the officer about what your field is, about what your jobs are, about what makes you special, and why the visa should be approved. So yes, we encounter challenges, especially with officers who don't quite get it, but we get the opportunity, on the other hand, to educate people, educate them about how the film and television world works, about how the particular art works. So we've got a question here. I'll answer it live. Very good question. What makes an artist a high achiever to be considered? Okay, so the O1 visa has a very off-putting formal name. The formal name for an O1 visa is a visa for persons or aliens of extraordinary ability. Now, most people, as you walk down the street, are not like a Donald Trump. They're not going to tell you how extraordinary they are. I've literally had conversations with multi-Oscar winning talent who will who have literally said things to me like, I just won my 3rd Emmy. Is that going to be enough? Okay, so you don't have to be an Emmy winner. That's not required. But what I'm trying to point out is that the way that the visa is talked about is, I think the name itself is off-putting. So we're talking about high achievers. We're talking about people who have a solid track record of achievement. The government looks at a series of what we call qualifying criteria. The qualifying criteria are written in legalese that I don't find to be very well drafted. You can look them up yourself, or I can find a link to the actual criteria. But here's how I put the criteria into plain English. The first is that you've worked in a leading or critical role for distinguished organizations. So you weren't collecting you weren't taking the coffee order, you weren't cleaning up after everyone went home for the afternoon. You were part of the group of people who led to the overall success of the project. And then we have to show that the projects are distinguished. The government does not define what a distinguished project is. So box office, ratings, other high-profile people who have worked on the project, favorable reception from the press, being awarded, say, jury prizes or official selections. So that's the first element, and probably the most important, because a lot flows from that. So to recap, the first element is that you've worked in a leading or critical role for a distinguished organization. The second, good press about you or your projects. Sometimes it's our jobs to make someone else look good. And say in that editor case, he didn't have a lot of press about him, but his projects, were short and feature-length films that went on to the festival market and to popular release. So the projects had been the subject of the favorable press. Awards, same idea. Ideally, awards given to you, but even if you haven't won an award, yourself, oftentimes your projects will have won awards. In fact, I always love it when my team and I are able to find and scour the internet and find awards and accolades that others that the client didn't know about, that others have given them. Letters of recommendation. This is a really key element. The formal designation is, and I might butcher this slightly, it's significantly high. Oh, how does this one go? I'm sorry, but this one goes significant recognition from experts, government institutions, or other noteworthy bodies, or something like that. The way it gets translated in real life is letters of recommendation. The way we do the letters of recommendation is very hands-on. I like to make sure that the best achievements, the best evidence is placed into the letters of recommendation. Think of it like this. If this was a case in front of a judge and a jury, a traffic accident case, a sexual harassment case, a contract dispute, whatever the case is, you would bring witnesses in front of the judge and the jury so that the judge and the jury could decide who's telling the truth and who's not telling the truth, who's accurate and who's not accurate, who's at fault, who's not at fault. We don't do that in immigration, at least in this practice. This is not a practice in front of a judge and a jury. This is what we call an administrative practice. So everything we submit to the government is in paper form, which my litigation colleagues can't quite fathom how that works. You're submitting a cold paper record to an immigration officer who is presumed to have no specialized knowledge in non-US arts and entertainment. So the letters of recommendation are absolutely critical to the presentation, because that's where you can bring in facts and evidence and expert opinion testimony. One point I would note is that the Immigration Service has been told by courts numerous times that they are not allowed to ignore the expert opinion testimony of experts. There was an important court case back in 2013 or 2014 called Skirball versus USCIS. I can send you the link if you like. So Skirball is a reference to the Skirball Cultural Center. If you've ever been to Los Angeles, it's a building near the Getty Center on the 405 freeway. It's a big sort of civic organization. They bring in speakers, book authors, and other performing groups. So Skirball had attempted to bring in what we call a culturally significant program. They wanted to bring in, of all things, a Jewish klezmer organization, klezmer music, traditional Jewish music from Central Europe, as interpreted by Central American musicians. Okay, very unusual program. In support of their request, they brought in an expert who wrote an opinion letter. The opinion letter concluded that this Argentinian klezmer organization was culturally significant, based on his years of study as an ethnomusicologist. The government said, we're just going to ignore, USCIS said, we're just going to ignore this expert opinion. We don't find it persuasive. They didn't have any reason to doubt the credibility of the author. They had no countervailing facts to undermine the credibility of the author. And so on appeal, the Court of Appeal reversed the decision and said, Immigration Service, you've got to consider the expert opinion testimony when it's presented to you. And I really hammer that with them in our cases, because the way that the rules are written, think of it like this. The way the rules are written is not for the immigration officer to determine whether or not he or she likes your work, whether or not he or she likes heavy metal music, whether or not he or she likes avant-garde photography, whether or not he or she likes risque material. I have clients who are in the adult film industry. I have clients who are in burlesque, clients who are in nightlife and entertainment. Whether or not the individual officer likes that art or does not like that art is irrelevant. The officer is there to evaluate what others who are in a position to know think about that artist. You know, say the burlesque dancer, maybe we have an immigration officer who has a, say, religious or moral objection to burlesque art. Well, that's not relevant to the decision, and for an immigration officer to ignore expert opinion that, you know, this particular burlesque dancer or this particular painter or this particular composer is at the top of their game is what we would call reversible error. It's a violation of the Skirball holding. So that's something that we have to do from time to time. Also, if the Immigration Service gets it truly wrong, truly egregiously wrong in denying, we have the ability to sue the government in federal court. I have had to do this a number of times over delays and over just them really getting it wrong. Ignoring evidence, mischaracterizing evidence. If they get it really wrong, I want to see them in court. Now, of course, that's separate from the case preparation. It's expensive, it's time consuming. It's not what I prefer to have the client to do, but it is an option. Okay. So that's the elements to show that a person has a high level of ability. In addition, we would also need to show that there's an itinerary of upcoming US-based work over a period of time. So again, this is an area where the government frequently gets it wrong. The government requires us to describe an itinerary of upcoming US-based events over a period of time. The government rules specially define the word events in an including but not limited to a conference, a lecture series, a tour, an exhibition, a business project, a series of related activities, or a contract. Now, one error that I see frequently is where the government misquotes that definition. I mean, the rule book's on that shelf over there. You can't see it, but I could pull out the rule book, and that definition is right there in the section called definitions. They misquote their own definition all the time. So part of what we have to do is correct them on their own definitions. That was actually a request for evidence that I was working on yesterday with the client, pointing out how the government got its own definition incorrect. So they don't make it easy for us. But you know, I would say there was no time during the Trump administration, no time, you know, during the Biden administration where my advice was, let's hold off on filing a case and wait for a better environment. We file the case, we see what they say. And the only way to test the evidence is to file a case. One thing that I see happen from time to time is, as we're preparing a case, as the case is getting near completion, and we're kind of making sure we're all happy with where the case is, and nothing is forgotten about, or no stone left unturned, that kind of thing. Sometimes people will get very anxious about filing a case, and they'll kind of seize up. I'm not a parent myself, but I would imagine that when the parents send the children to college, it's kind of like that. It's like you've raised the kid, you want the kid to make the right choices, you want the kid to succeed, but it's going to be out of your hands pretty soon. So one thing that I would, when that happens, one thing that I remind my clients is that it's out of our hands. We always have the burden of proof. It's always up to us to prove that the person's qualified. It's not up to the government to prove that the person's not qualified. If we file a case and they don't approve it straight away, either under standard or premium processing, they'll come back with a request for evidence. If they come back with a request for evidence, some are more complicated, some are more straightforward. we see what they say, we respond, and hopefully we get an approval. If we get a denial is without prejudice towards future cases. We can try again, and perhaps a different officer looking at the same evidence can come up with different results. I've seen that happen too many times to count. There are citizens today who are voting, who are sponsoring family members, who are fully integrated into this country, who at some point had faced a challenging immigration time, who had maybe even been denied. So the name of the game is persistence and planning, and the worst thing you can do is be discouraged. I always want to be very real in these discussions, because the Immigration Service does not make it easy, but this is the system that we've got. And there's a lot of time that I devote every year to advocacy, to meeting with members of Congress, to meeting with congressional staff, to meeting with higher ups at USCIS and the State Department, advocating for a fairer, more humane, more streamlined, less error-prone system. But until we get there, this is the system. Now, that being said, the vast majority of our cases get approved. If we get requests for evidence, we just respond very logically. So I always want to balance the optimism with maybe the realism of how the system works. If there are no other questions, I'll let us go. Like I said, I'll send an email later with some of the links to the things I mentioned and a copy of this recording. Thank you all so much for joining me this morning, and have a great start to 2024.